In the matter of Consolidated Construction Consortium Limited versus Software Technology Parks of India, Supreme Court dismissed the appeal and said that learned single judge had clearly gone beyond the grounds provided in Section 34 of 1996 Act to set aside the arbitral award. Software Technology Parks of India, that is, respondent, following a tender process, had awarded contract to MS Consolidated Construction Consortium Limited, that is, the appellant for construction of office building, incubation center, etc. of respondent. As per letter of intent dated 9 March 2006 issued by respondent, total cost of project was rupees 16 crore 48 lakh 69,970. Scheduled date for completion of construction was 15 January 2007. Appellant could complete the construction only by 30th November 2007, thus there was a delay of about 10 months. Appellant, after handing over the project site to respondent, claimed sum of rupees 1 crore 40 lakhs 12,786, including retention money and interest. However, because of delay in completion, respondent levied and deducted liquidated damages to the tune of 82 lakh 43,499 by invoking clause 26 of contract agreement entered into between the parties. Respondent also made other deductions. After such deductions, balance amount of 3 crore 3 lakh 70,992 was paid by appellant to appellant by respondent. Aggrieved appellant invoked arbitration clause of contract agreement and initiated arbitral proceeding challenging deduction of liquidated damages by respondent and also lodged other claims. Respondent also lodged counterclaims. What arbitrator noted in this case was that on number of occasions appellant had sought for time. On each occasion, respondent was compelled to allow the appellant to carry on with work beyond extended time period by granting further extension, reserving its right to levy liquidated damages. Conjoint reading of section 55, 73 and 74 would indicate that in contract, whether time is of essence or not, if contractor fails to execute the contract within specified time, the contract becomes voidable at option of promisee, and promisee would be entitled to compensation from promisor for any loss occasioned to him by such failure. However, in case of contract where time is of essence, contract becomes voidable on account of contractor's failure to execute contract within agreed time. Promisee cannot claim compensation for loss occasioned by such breach of contract unless he gives notice to promisor of his intention to claim compensation. This is made more specific in Section 73. Section 74 contemplates the situation where penalty is provided for and quantified as compensation for breach of contract. In such a case, party complaining of breach is entitled to compensation whether or not actual damage or loss is proved to have been caused thereby, but such compensation shall not exceed quantum of penalty stipulated. Supreme Court said that scope of Section 34 of 1996 Act is now well crystallized by plethora of judgments of the court. Section 34 is not only nature of an appellate provision, it provides for setting aside arbitral award, that too on very limited grounds, that is, those contained in subsection 2 and 2a of section 34. It is only remedy for setting aside arbitral award. An arbitral award is not liable to be interfered with only on ground that award is illegal or is erroneous in law, which would require reappraisal of evidence adduced before arbitral tribunal. If two views are possible, there is no scope for court to reappraise the evidence and to take other view than the one taken by arbitrator. This view taken by arbitral tribunal is ordinarily to be accepted and allowed to prevail. The scope of interference in arbitral matters is only confined to extent envisaged under the section. The role of court under Section 34 of 1996 Act is clearly demarcated. It is a restrictive jurisdiction and has to be invoked in a conservative manner. The reason is that arbitral autonomy must be respected and judicial interference should remain minimal. Otherwise, it will defeat the objective of the 1996 Act. Learned single judge noted that contract work was required to be executed within 10 months period. Appellant could not complete the work within the contract period due to landslides and rains. Ultimately, appellant could complete work by 30th November 2007 by seeking extension of time which was granted by respondent. There is no complaint about construction. Single judge also noted that there were rains and landslides during contract which is not in the dispute. Learned single judge also observed that clause 26 of contract agreement could not be read in isolation without reference to clause 27. Fact that appellant was allowed to carry on contract work and to subsequently complete the same cannot be denied. Once there is extension of time, there cannot be narrow interpretation to clause 26. Purpose of extension of time was only for completion of work. Extension of time and levy of liquidated damages cannot go hand in hand. Contention of respondent would have been acceptable had there been no extension in time or the work remained incomplete even after extended period. In such an event, respondent would have been justified to levy and recover liquidated damages. Once appellant had completed the work during extended period of time, claim of liquidated damages by respondent could not be accepted. Therefore, arbitral award dated 10th May 2010 was set aside. Court held that learned single judge exceeded jurisdiction under Section 34 of 1996 Act. There was no justification for setting aside arbitral award by taking a different view. View taken by arbitral tribunal is certainly a possible and plausible view. Different interpretation of clause 26 other than the one taken by arbitral tribunal is possible, but that will not bring challenge to arbitral award within four corners of Section 34. Mere setting aside of arbitral award did not confer any benefit to appellant. In these circumstances, division bench was justified in reversing the order of learned single judge under Section 37 of the 1996 Act.